I'm Ed Lee, the director of the IP program. You've seen me before.
And I'm Dave Schwartz. I was on a panel this morning. I'm the co-director of our Center for Empirical Studies of Intellectual Property Law.
And we have a short 15-minute presentation, the first PowerPoint slides of the conference, for an exciting addition to our Supreme Court IP review. We plan on offering this every year to the extent that the court keeps on granting cases involving IP law. And as we said at the start, this is a historic term with 10 IP cases, the most ever in the Supreme Court's history. And we thought, given this historic sort of term, it'd be good to take stock of what the Supreme Court has been doing in IP this term, as well as look back a little bit with previous terms. So we're planning on writing a law review article based on this. This is still a draft, and I would just mention the slides in your program have been corrected in some respects, so they won't be exactly the same as we're presenting right now. So we decided to take a look at 4 issues that have been looked at in the past by other commentators on Supreme Court practice as well as scholars. The first 2, reversal rate and unanimity and alignment of justices, you often see in the Harvard Law Review November issue as well as on SCOTUS blog. So I think the first issue is pretty self-explanatory, how often the Supreme Court has reversed or vacated the lower court decision. The second issue, looking at how often the justices are actually unanimous in opinion, and there have been some New York Times articles written about that topic recently, as well as the alignment of justices, meaning which justices vote the most or least together. And then we looked at 2 other issues that have been written about in law review articles. The first being the involvement of the Solicitor General and whether that involvement tends to coincide with the winning side in a case. And in this term, this SG was involved in 9 of the 10 IP cases. And then finally, we looked at this fun sort of look at the number of questions during the oral argument. Does it, in fact, correlate with the losing side receiving more questions in oral argument? And a number of scholars, Judge Posner, Chief Judge Justice Roberts, and others have shown that in previous oral arguments that does bear out. Okay, so that's those are the 4 main issues we've looked at.
Okay, so let's first start with reversal rates. Before I get into reversal rates, just keep in mind this is just kind of basic descriptive information from this one single term of the court. We're going to keep doing this going forward, but the sample is small. And so when we look at what we have here are the cases broken out by patent, copyright, trademark. And so we've got 1 patent case affirmed and 5 reversed. We've got 2 reversals in copyright cases, and then we have 1 trademark case affirmed and 1 reversed. And so that works out overall to be 8 reversals and 2 affirmances, or 80% of the cases are reversed. So a few things to note about that. First is that when you look at all cases that the Supreme Court decided during this term, they reversed 73% of the cases. Okay, so they usually take cases when they are have some concern about the lower court judgment. Now, the Federal Circuit, I think, is a special case because usually there's a circuit split or some other reason that they take the case where there's a chance that they take a case that they're going to affirm. With the Federal Circuit, they likely take cases where they're just unhappy with the result and are more likely to reverse. And then the other thing to keep in mind, we have asterisks here. And so there was 1 Federal Circuit case that was affirmed. That's the Alice case. That was a 6-6 decision that had affirmed a lower court finding that all the claims were invalid. And so that's technically an affirmance, although the Federal Circuit's opinion was very short for the, in that case, the main opinion, and everything else was just a concurrence. And then the Lanham Act case, the one that was affirmed, the Supreme Court actually rejected the rationale and the rule that the court used. So even these affirmances are not strong affirmances. And so now let's look at unanimity in the court. And so here we have unanimous, in the patent cases, all 6 cases are unanimous. 5 unanimous reversals and 1 unanimous affirmance, and that's the Alice case. The copyright cases both resulted in non-unanimous 6-3 decisions, and then both trademark Lanham Act cases were unanimous, one in affirmance and one in reversal. And so just to keep in perspective here, we have 8 of 10 cases that are unanimous, and overall the court was, had 66% of its decisions or opinions be unanimous in the term.
Okay, now we could turn to the voting alignments issue, and this is kind of a scary chart here. It's similar to the one that the Harvard Law Review publishes in the November issue, and this is obviously just a small sample of 10 cases from this past term. So take this analysis with a certain amount of grain of salt. But we looked at which other justices each justice voted the most with and the least with, and the highlighted portions represent those justices voting most together. And it turned out if we list at the bottom here, the most popular pairings were trios, were Justices Ginsburg, Sotomayor, Kagan. They happened to be in all of the majority opinions. And they voted all together all the time, only in the majority opinions. Whereas the other two trios, Chief Justice Roberts, Kennedy Breyer, dissented in one opinion, and Scalia, Thomas, Alito dissented in another opinion. And if you look at the analysis of SCOTUS blog comparing the voting blocks generally for this past term, this is pretty consistent with all of the cases from the past term combined. The one difference is that Justice Breyer voted more often with the block of Ginsburg, Sotomayor, Kagan in the collection of all the cases from the past term. We also looked at the participation of the Solicitor General in the cases. As I referred to before, SG participated in 9 of the cases. And it turned out that the SG was on the winning side in 7 of those 9 cases, and in only 2 of the 9, the SG's actual position taken in its brief was not endorsed by the Supreme Court or not adopted by the Supreme Court. And I should mention, just coming off the heels of the last panel, the Palm Wonderful case was one of those cases in which the SG's position, which argued for an intermediate kind of preclusion of the false advertising claims, was not adopted by the Supreme Court. So that was very interesting. And then finally, we looked at this fun issue of how many questions did each oral advocate receive, just looking at the parties' attorneys. And if you look at the highlighted portion here, it turns out that in 7 of the oral arguments, the losing side counsel received more questions than the winning side, which carries out the conventional wisdom in the literature. And if you actually look at the numbers, 6 of the 7, I believe the numbers are pretty disparate. The differential between the number of questions for the winning side counsel and the losing side counsel were pretty dramatic. The 3 other cases, at least by our count, were a tie. And if you might quibble on what's a question, what's just a statement and a continuation of a previous question, but at the very least, these would be close calls as opposed to a very disparate number of questions between sides. So the takeaway points from these 4 issues we've highlighted in your program. We're not going to walk through them today again here in the interest of time so we can leave some time for questions. But if you want to take a look at the takeaway points we believe from this quick study of the past term, I'll refer you back to the conference program.
Okay, and then we're starting to look at some historical trends, so looking at cases beyond just this year's term. And so when we do that, we see there's just been kind of a rise, not only this year, but a rise in the last few years in IP cases. And so here what we have are the IP cases from the last 60 years, from 1950 all the way till 2014. And we can see that it kind of bounces around, and there are years with kind of larger numbers of cases. But in the last decade, we see a relatively large increase. I mean, going from, on average, like 2 to 3 to, kind of a high water mark this year of 10, but a few years in a row with like 6 or 7. And so then we decided to blow that up a little more just this recent period. And so the last 10 years. And so when we look at that, or the last 13 or 14 years. And here what we've done is we've divided them out not just for IP cases, but the patent and the copyright and the trademark cases and the false advertising cases separately. And we see that a lot of the growth has occurred just in the last few years, and these patent cases are the ones that are driving at least the most recent growth. So we have 6 this year, and we had 4 last year, and we had 3 the year before, and 3 the year before that. But early in the 2000s, we had 0, 3, 0, 0, 1, 0, right? So much lower numbers of patent cases. And so this is something we're going to continue to follow, and we're also going to start looking, on a more granular basis going backwards. And so with that, we welcome questions.
We have a couple minutes left for if anybody has any questions. There's a mic coming over.
Just out of curiosity, what is actually spurring these numbers? I mean, what's actually spurring more?
Yeah,
That's a good question. I think the Supreme Court is interested in patent law. They either think that the Federal Circuit is getting cases wrong, or advocates are, another ideas that Supreme Court advocates have been drawn to these cases, and in maybe 15 years ago, the Supreme Court bar was not handling these cases, and they just didn't get the attention of the justices. I mean, so that's kind of an open question, but clearly patent law is more in the news, and the justices, are causing some of that news and maybe reading some of that news as well.
Yeah, I think this question will be posed to the last panel, but just to speculate a little bit, and I'll add to what David said, and I'll refer back to David Campos's speech talking about how important IP industries are to the economy of the United States. And I think it was 2004 when the FTC came out with a report suggesting that our patent system in some respects is hindering innovation. And that you can see from some of the patent cases granted in 2006, there were 3, and then we have at least steady number in the past 4 years. And I think the Supreme Court recognizes it has a role to play in this space because of how important IP is to the overall health of the U.S. economy. So that it would be sort of remiss if it did not get involved, especially if it thinks the patent laws might be, for instance, too permissive in allowing business method patents. That was sort of, I think, a follow-up after the FTC report came out. Other questions? Comments? Okay, great. Well, we'll continue to work on this, and it'll be in a law review at some point, hopefully soon. So thank you for your comments, and appreciate it.